So welcome everybody to this webinar, which we've called Fixed Penalties and Commercial Driver Court Cases. I thought what we would do in this session is look at where we are with fixed penalties since their introduction, or the introduction of fixed penalties really for the road transport sector in 2009. We'll look at how you should deal with fixed penalties procedurally, and then we'll go and look at some things related to court proceedings and how fixed penalties tie in with those court proceedings. I'll also be giving some pointers about how drivers can avoid penalty points and driver disqualifications. Some of those are less well-known points which you might find useful in your businesses. Now, fixed penalties are very widely applied. Thousands and thousands are imposed for straightforward road traffic offences like speeding, but really in the commercial sector for goods, vehicles and passengers, things didn't really change significantly until about 2009, when they were introduced through the graduated fixed penalty scheme, which really deals with driver's hours and excess weight and that kind of thing. And also introduced fixed penalties for a wide range of other goods and passenger offences. And prior to that, what had really happened was that if action was taken against you as an operator and a driver by the police or DFSA, you would be prosecuted as the operator and the driver. But what happened in 2009 was the emphasis completely changed and shifted over to the penalties being imposed against the drivers and the operators not being pursued in that particular way. So let's have a look, shall we, about the advantages and disadvantages of the fixed penalty scheme. The fixed penalty scheme is a very simple scheme, and in many cases it works pretty well, but it isn't a good fix for all different types of cases, as we'll see in a moment. Now, my view is that there are a few advantages to the fixed penalty scheme. The first thing, of course, is that every driver knows exactly where he or she stands. It's the same penalty in every single case, it's the same for every driver. So if you commit offence X or Y, it will be a penalty of £100, £200 or £300, whatever it is. And it's something which is very easy for the police and DFSA to administer, particularly at a time when there are huge financial constraints and it's expensive to prosecute. And an advantage for operators, of course, is that the operator no longer receives a penalty, isn't prosecuted, and in most cases actually isn't issued with a fixed penalty. Theoretically, a sole trader or a partner can be issued with fixed penalties, but that doesn't tend to happen, and if there's any action, it's via the traffic commissioner. And it's sometimes said that in fact fixed penalties are a good way of ensuring that drivers are compliant, because they've got a disincentive to fail to comply, because they can be hit in their pocket if they don't abide by the driver's hours rules or have a fit and serviceable vehicle. There are, however, some disadvantages that can occur when fixed penalties are applied. It's certainly the case that often a fixed penalty is imposed when an authority wouldn't prosecute, because it's easy to impose a fixed penalty. And also fixed penalties don't really suit more complicated cases, or cases where there are twists and turns and quirks, where somebody may have a defence. One big problem, we'll see this in a moment, is that if you want to challenge a fixed penalty and you can't get the police or DFSA to discontinue the case, and you want to go to court, well, it's very expensive to do so, particularly if you want legal support. And in essence, a driver can be put off going down that route. There are a couple of other things that I think are a problem with fixed penalties. If you have multiple fixed penalties, then drivers can end up with fixed penalties which are higher than the court finds that would expect to receive for the same case, and it can be a very high proportion of the driver's take-home pay. And the final point is that I think in some cases there is an unfairness. Drivers do receive fixed penalties when in fact they are morally blameless. Excess weight is an example. You do have cases where a driver is driving a vehicle with excess weight. There may have been a weight misdeclaration, whatever it is, and really they're not at fault, but they have to pay the penalty. Now let's just have a think about the fixed penalty procedure. The procedure is slightly different in Scotland, and I'm really dealing with the procedure that we have in England and Wales. So what will normally happen is that a driver will receive a fixed penalty, and remember, a fixed penalty is in essence an alternative to going to court. So the driver will receive the fixed penalty. If it's a driver who hasn't got a satisfactory UK address, then there'll be a deposit payment required by DVSA or the police, which will effectively be a deposit against the penalty that has to be paid. But normally with a UK driver with a straightforward UK address, there'll be a fixed penalty. And in addition, DVSA will notify you, the operator, so that you can in turn be aware of it and notify it to the traffic commissioner. Now at this point, what needs to happen is that there should be an investigation that's carried out. We'll look at this in a moment on a separate slide, because a decision has got to be made what to do within 28 days. I tend to find that if you ask the police to review fixed penalties, you don't often get much change. Sometimes you can speak to the road policing unit, and it's possible to challenge successfully, but often it's a sort of take it or leave it. If you want to challenge the penalty, well, go to court. There is a DVSA review procedure. The details are on the back of the fixed penalty notice. So you can go through this review procedure, and then if you don't get any joy, you can still opt to go to court or pay the penalty. So you'll then be in this situation where you make a decision what to do, but you've actually got to take some kind of formal action. You can't just let things drift, because there are consequences. And we can see the consequences here on the left-hand side of what will happen if you don't reply. So if you don't reply, or if the driver doesn't reply within 28 days, what then happens procedurally, it's lodged as though it's a court fine, and there is an uplift of 50% of the fixed penalty. And also that happens because if the driver produces his or her driving license, because it's an endorsable offence, but the fixed penalty is actually unpaid. That is the same consequence there. So let's assume that the driver, because it will always be the driver's decision, is to pay the fixed penalty. Well, that's straightforward. It has to be paid within the 28 days, and you as an operator will inform the traffic commissioner of that outcome. I'll come to a point in a moment about what triggers the notification of the fixed penalty to the traffic commissioner, because there is a quirky point there which we'll look at. So if the driver doesn't want to accept, in other words, pay the penalty, and wants to contest the case, then the driver must formally do something, can't just let it drift, or the driver ends up in this situation over here. So the driver will have to formally decline and say, I want to go to court. The driver will also end up in court if it's an endorsable offence and the driving licence hasn't been produced to the authorities within 14 days. So in those two circumstances, there will be a court process. There will also be a court process if the driver's got too many penalty points on his licence and is liable to tot up. So in that situation, the driver goes to court, and in due course, a court summons will be received, and I'll be telling you in a moment about a particular procedure where court proceedings start under the single justice scheme in a little while. I've just made a note there about unlimited fines. I think as operators you do have to remember that for offences that previously had a £5,000 maximum, that maximum does no longer exist, and so it's unlimited fines in the magistrates' court for those offences. My thoughts on what you should do about fixed penalties, procedure, how to deal with fixed penalties. My first point is carry out a full investigation. Invariably, there will be a prohibition that's issued at the same time as the fixed penalty. So just investigate everything as you normally would. Get all the paperwork together, receipts, invoices, explanations from the drivers, any driver disciplinary paperwork. Put that all together and keep it in a file and keep it for 5 years, because traffic commissioners can take into account prohibitions and these penalties for a period of 5 years. The driver, and it's the driver's decision, ultimately has to decide what to do, to pay up or challenge the fixed penalty in opting to go to the court, and often taking a risk. Should operators pay driver fixed penalties? I think our advice would probably be, in the ordinary course of events, I don't think it's a good look for operators to be paying driver penalties if the drivers have committed offences, they've been negligent, non-compliant, or whatever. I do think in some circumstances where the driver really isn't at fault, perhaps an excess weight case, as I mentioned before, that the operator may take the view that it's only right and proper that they should pay the penalty. And then finally, as we said before, notify the traffic commissioner, and you could decide whether it's going to be a fairly mundane, matter-of-fact notification to the traffic commissioner, or whether the circumstances are such that you might want to put a really detailed submission into the traffic commissioner, particularly where you may feel aggrieved by it. And we'll be talking a little later about a case called Hart and Becks, where an operator and driver can be morally blameless and may want to point this out to the traffic commissioner. Just a reminder here that you do have to notify the traffic commissioner of fixed penalties. This is in the Goods Vehicle Licensing of Operators Act 1995. The quirky point that I mentioned a moment ago is that the law actually says that you have to notify the issue of fixed penalties. In other words, if they're issued, it seems to be, well, at that point you have 28 days to notify. So what do you do if in fact a fixed penalty has been issued, but you're going to contest it in court, and in the court proceedings, well, you found not guilty, or the driver's found not guilty? Certainly the discussions I've always had with the Office of the Traffic Commissioner is that there is a view that it's if the fixed penalty is paid that is what is really meant there. But to the letter of the law, the exact wording of the legislation is if fixed penalties are issued. Remember that fixed penalties issued to nominated transport managers have to be declared, and if you want a list of all the fixed penalties, what is and what isn't covered by what are called notifiable fixed penalties, then look in the Road Traffic Offenders Act 1988. There's a long schedule in Schedule 3. So what do we do about fixed penalties? Should we pay them or should we contest them? As a rule of thumb, I think you're always likely to pay the penalty rather than opt for court, unless it really a couple of sets of circumstances are present. Either you're pleading not guilty, or it's an endorsable offence and the driver wants to avoid driver penalty points. One thing that has to be borne in mind is that if a driver opts for court, then to all intents and purposes, we have this thing called the tax on innocence. And the cost rules in criminal court proceedings are very brutal. It's almost impossible to get your defence costs back. You might be able to get a small amount, a small proportion, but really if a driver is going to contest the case, or if the operator is going to assist in the driver contesting the case in court, then probably all your legal costs you're going to have to bear yourself. It's very unfair, but that is the state of play with cost rules in criminal proceedings. As an operator, you might decide, for the greater good, to support your driver because you want to protect the operator's license, that you'll help the driver out. That's perfectly permissible. You know, you'll help the driver out with legal fees and things like that. But ultimately, the driver has to decide what to do, because if the driver fails in the court case, then it's a conviction against the driver. Now, I've not put driver's hours fixed penalties on this particular list, but I thought I would create a schedule, and it's in alphabetical order there, of some of the main fixed penalties that you're likely to see as operators and drivers. You'll see in the sort of darker colour here, these are really construction and use offences. I'm going to look at those in a bit more detail later. But you'll see that for brake, steering and tyres offences, that's an endorsable offence, 3 penalty points, fixed penalty £200. There are other offences which are not endorsable for the construction and use. Excess weight, which is a construction and use offence, there are no penalty points, remember, for weight offences, but there's a sliding scale of penalties for excess weight. Handheld phone, we'll mention the change in a moment, but that's a construction use offence. Remember, the penalty is 6 points, so it's a very hefty penalty, quite apart from the Traffic Commissioner driver conduct hearing that a driver may face. That's a £200 penalty. And finally, there's a further offence, which is using a vehicle in a dangerous condition. That may be where there's an insecure load or whatever. Again, 3 penalty points on the licence for that offence. On this table, I've mentioned a few other offences which you might like to think about. Careless driving. If a driver accepts a fixed penalty point, for that it's 3 points, but if you go to court, then the court's got the power to impose up to 9. Similarly, for driving licence offences, 3 points, the court can go up to 6. There is a fixed penalty, that's the lower amount, £50 for driver CPC offences. And if a driver hasn't got a CPC at all, hasn't taken one, its DFSA policy is referral to the Traffic Commissioner. Failure to supply driver ID bears 6 penalty points. Now, as a business, if you operate as a limited company, you can't have your there's no personal company driving licence. But if you are a company director, secretary, member of staff, and you have connived in the non-supply of your driver ID, you can receive a personal summons or a fixed penalty, and it's 6 penalty points. Finally, no insurance. I'm going to tell you a little bit later about a special driver defence for no insurance, but that's 6 penalty points and a £300 fixed penalty. But if it goes to court, 6 to 8 points. So these are some of the main fixed penalties that you're likely to encounter as an operator and a driver. Just a heads up about 1 or 2 law changes where there will be, this will impact on fixed penalties. We'll be saying more about this later, but in February 2021, there's going to be a change of the construction and use rules concerning old tyres. So no tyres more than 10 years old on front steered axles, and that'll be an automatic S-mark prohibition. They must also have legible manufacturer date code. There's some other provisions. We'll talk about that in the new year. Mobile phones, in the new year, we'll see a widened scope of the prohibition on their use. In effect, it will be any use of mobile phones in any way whatsoever. So that will include taking photographs and any activity at all. And as we're dealing with Brexit, you'll be familiar that if you want to engage in international work, you need to have a Kent access permit. And if you're found in the Kent area intending to go to Dover or to the Eurotunnel terminal and you haven't got the paperwork, then it's a £300 fixed penalty. I've mentioned the various fixed penalties that there are that relate to construction use offences and other things. I thought we'd mention the approach adopted by DFSA concerning driver's hours. Now, the basic scenario is that you have graduated fixed penalties depending on the extent of the offence, how little rest you've had, or the excess driving the drivers engaged in, and these are £100, £200 or £300. False records, fraud are not within the fixed penalty scheme, and they lead to an operator investigation and referral to the Traffic Commissioner. You'll remember that it's now possible, has been for a few years now, for DFSA to impose penalties for historical offences. So not offences just committed on the day of the driver stop, but those which can be found on the records for the previous 28 days. But in practical terms, and we'll see this on the next slide, to do that, they have to be the more serious offences called Band 4 offences, or they've got to be more than 3 offences in the lower bands for those offences to be mopped up. And if you have quite a number of historical fixed penalties, you as the operator will be followed up by DVSA. As we'll see in a slide in a moment, if you have more than 5, then proceedings will be taken against the driver in court and possibly also the operator. And a final point, remember that there seems to be some misunderstanding about this. You don't get points or disqualifications for driver's hours offences. They don't carry them. Now the DVSA has sorry about that. The DVSA has issued this table, which basically explains when a driver is going to be referred to court or the operator is going to be followed up here. And in this area here, the combination of current offences or historical offences that can be dealt with by way of fixed penalties. So if you're in this band here, then you can be dealt with in these combinations, this sort of different cocktails of historical and current offences. But if there are more than that number of offences, you go to court. Now, I thought we would put in a little bit about this thing called the single justice procedure. If you are on the receiving end of court proceedings as a driver or as an operator, I mean, this just doesn't relate to fixed penalties. It can be regardless of that. There is something which is called the single justice procedure, and if magistrates' court proceedings are commenced under this system, what happens is that you receive a notice and it says on the top single justice procedure. And what you have to do there, rather like other court summonses, is you have to decide what you're going to do. You're going to plead not guilty, or you're going to plead guilty in writing, or you're going to plead guilty, but you're going to request a court hearing. Now, the difference with the single justice procedure is that there isn't actually a court date and time that you go to. What happens is that there's a single magistrate sitting with a court clerk with a pile of these summonses, and they go through the list of all the replies, and if you've pleaded guilty in writing, they will impose a fine and costs and a victim surcharge, and then send that out to you. So you don't physically attend court. If you don't reply, then you may be convicted in your absence. If you do reply and you want it to be dealt with in writing, then they'll sentence you and you just receive that in due course. If you want to attend, they'll adjourn it to a new court date, and if you want to plead not guilty, it will go off for a trial date into what I'd call the normal court system. My view and advice to you as operators is that if you find yourself in this system, I would opt to go to court, because transport cases are generally too complicated to be dealt with in writing. They need to be explained in detail to the magistrates. And you wouldn't be penalised by the court for asking to be dealt with in person. And you're likely to have a better outcome. So what we're going to do in this sort of, in the final part of this webinar, is take a look at what happens in court and how drivers can avoid penalty points and disqualifications, and perhaps have some defences to certain offences, particularly construction and use offences, the ones that are highlighted in the dark colour there. A very useful thing for you to know is, and I don't think this is widely known, is that in fact the court isn't permitted to impose penalty points or driving disqualifications in certain circumstances. And these circumstances relate to construction or use offences, using vehicle in dangerous condition, or where there are breaches of brakes, steering or tyre rules. And so this is actually in statute, and the statute says that the court cannot order a person to be disqualified or have points if the person, and this can be either the operator or the driver, proves they did not know and had no reasonable cause to suspect that the use of the vehicle involved a danger, or the facts of the case were such that the offence would be committed. So basically, the court is not permitted to endorse the licence. How this links in with fixed penalties is, of course, you could have a driver who receives a fixed penalty, and it's an endorsable offence. They pay the penalty and they get points on the licence, but in fact, if they went to court, they wouldn't get points on the licence. So it's an interesting point that operators and drivers need to think about, and perhaps one that's not particularly well known. I think there is also something that you could use as operators, particularly you're writing to the traffic commissioner about a penalty or a prohibition or whatever. There's a case called Hart and Becks. It's quite a well-known case for road traffic and road transport lawyers, and it all relates to a case where there was a defective braking system, and the court said this is one where a driver couldn't be expected to inspect the brakes, because a driver doesn't inspect brakes in detail, the inside of brakes, on a daily walk round check, and the driver couldn't have known of it, and there was a unexpected and sudden failure. The court said in that particular case that firstly, there shouldn't be a prosecution, but if there is a prosecution, the court should take no action by imposing what's called an absolute discharge. And that's where they feel that the operator, the driver, is morally blameless. So that might be something that you'd want to use when you're writing to the traffic commission. Say, traffic commissioner, this is what happened in this case. It's a Hart and Becks situation. Most traffic commissioners should know what Hart and Becks is. And you can say that there shouldn't have been a court case, there shouldn't have been a fixed penalty or whatever, because the driver or you as an operator were morally blameless. And I dealt with a case a few years ago that was very interesting and along these particular lines. The facts of the case are really these. There was the driver who in fact was a trained fitter, but after many years he'd started driving and was a very good driver, excellent daily defect procedures. He was driving along in his lorry and he was approaching a junction on the left-hand side of the road, and there was a car parked in the junction awaiting to emerge, and the driver wasn't best pleased to see rolling towards him a rear tyre that had come off the trailer. Unfortunately, it narrowly avoided the car in the junction. It veered off before it struck the car. So the question was, why did this happen? And it transpired that the workshop had worked on the trailer the night before, had had a wheel off, had reattached it, but there had been no procedure in place to inform the driver of this. So he had absolutely had no idea. So therefore he couldn't, check the torquing of the wheel that morning because he didn't know anything about it. But what was good about this driver is that we were able to go back over his old defect books, and when he knew that a tyre had to be retorqued, there were stacks of evidence of that from weeks and months before. So we used that evidence in court, and the court agreed that the driver was absolutely blameless and gave him absolute discharge. No points on the licence and no prosecution costs. Now the interesting thing is, if that had been today and the driver had been issued with a fixed penalty, the driver might have accepted the fine and the penalty points on the licence for something the court would have given no penalty. So it is worth thinking about this from a driver's point of view, and also for you as an operator, because it's a good thing to be able to report to the Traffic Commissioner that the court imposed an absolute discharge. In the final part, we're going to look at some other court-related issues. If a driver wants to avoid points or driving disqualifications, there are basically two ways of doing this. And one is to say to the court there's something special about the case. It's what road traffic lawyers call special reasons. And it's got to be something that is to do with the offence. It's got to be something which is mitigating. It can't be a defence, otherwise you'd be pleading not guilty. And it's something that the court can properly take into account. So if you want to contest cases avoiding penalty points and also reducing fine, you argue what's called special reasons. Quite separately, there's something called special mitigating circumstances. And these are cases which I'll mention in a moment, often where a driver will have 9 penalty points on the licence. They're going to receive another 3 or more points, and they're going to be disqualified for a minimum period of 6 months under the totting up rules. So just to explain that, because obviously this will happen quite frequently for businesses, you have a driver who's accumulated points. It could be for 2 mobile phone offences, because 2 times 6 points is 12 points. The procedure here is that the driver can argue that there are special circumstances why the ban should not be imposed. And if the ban isn't imposed, the driver simply has the licence endorsed with the points. The points sit on the licence until they drop off after the normal 3-year calculation period. Now, normally drivers argue that they shouldn't have points on the licence, they shouldn't be disqualified because they would suffer extreme hardship. They're perhaps the sole breadwinner in the family, they would lose their job, they've got dependent relatives, they've got children who are ill or whatever. And the law here is that you cannot argue hardship unless you are arguing that it's more than ordinary hardship. It's got to be exceptional hardship. And it's quite a high threshold to reach. So it isn't simply good enough to say there'll be hardship, the driver will suffer because of the ban, because it's the intention that there be suffering through a driver disqualification. It has to be a good level, a significant level of great hardship that has to be proved. Now, the final point I wanted to raise before the end of this webinar is something, again, which isn't particularly well known, but could be very useful for your business and for an employee driver, and that's in the context of no insurance. It sometimes happens that inadvertently a driver is driving for your business and is not actually insured. It could be because there's been a change of vehicles on the fleet and new vehicles come on and the ones being taken off, whatever. But there's an error of some kind. And so technically the driver doesn't appear to be insured. They're stopped by the police or whoever it is, and there may be a fixed penalty that the police want to impose, or they offer it. So that'd be 6 points plus the penalty. And I've seen drivers pay these and have their license endorsed, and in one case they totted up unnecessarily, not knowing that there's in fact in section 143 of the Road Traffic Act a specific defence. And it is the case that if you've got an employee driver and the vehicle is obviously operated by you, the operator, and the driver is using the vehicle in the course of his employment, and he didn't otherwise know that there was an issue, you know, he had a driving licence and was always going to be properly documented, the driver shall not be convicted. So there's a statutory defence. So I hope that is actually a quite useful tip for your business and for your drivers. So an employee driver should not normally pay a fixed penalty. Instead, what you should do is you should write to the police, the Crown Prosecution Service, the court, to explain the defence and ask that first of all, don't accept the fixed penalty and opt for court, where you've got an absolute defence and you should normally be acquitted of the offence. So that's the end of this webinar. We've looked at fixed penalties, we've looked at court proceedings, I've explained some of the twists and turns of what happens in court, and I hope that you'll have found that interesting and that you've perhaps learned some new twists and turns in the road traffic, the road transport court procedure system. And we'll be back doing further road transport seminars in 2021. If you'd like any more information from us, there are my details there. Do get in touch, drop me an email, and we'll be happy to assist. So thanks very much indeed for listening, and we'll see you again soon.